So let's get started. Thanks a lot for joining us. Okay, so just a short agenda for us today. I'm going to tell you a little bit about ClearEstate and who we are, and then I'll introduce my colleague Sarah, who will get into what is an estate plan, why it matters. We'll tell you some things about the planning process, as well as some real life case studies, which we find really help relate these situations to your lives, and then where you can go to get help with some time at the end for a Q&A. So who is ClearEstate? Perhaps some of you have been able to join some of our webinars in the past, but for those of you that are new, ClearEstate is a company that is here to support you in life's most important moments. So we are a company that will be able to assist you with creating an estate plan, which includes making a will and your power of attorney documents. And we are also available to help executors to settle an estate. So we have experts in all of those situations to make it easier and better to understand when it comes to estate planning and estate settlement. We have services for every situation, and we are affordable, about a third of the cost of lawyers in most cases. Streamlined, we have our own platform that we've created to make these services much easier to view and get through and understand and access. And we are personalized, which means we have all of the experts you need here under one roof at ClearEstate to give you the guidance and support that you need when you're going through estate planning and settlement. So the learning outcomes today, you're going to learn tips for how to build an effective estate plan that will safeguard wealth, minimize fees, and ease the burden on loved ones, and then where to turn for help so that you can make sure all of those things can happen for you. And just before we get started, we're going to ask our first poll question. So do you have a will and power of attorney documents in place? I'd love to know the answer. There's a poll coming up here for you to respond. We'll just give it a few seconds. The options are yes, I have a will. Yes, I have a will, but I don't have POA. Yes, but my will might be out of date. And no, I don't have a will or POA documents. And as you're answering, I'll let you know it is quite common to be any of the second to last answers. Yes, but it might be out of date, and no, I don't have one. Looks like we have a pretty good crowd on hand here who are better than the Canadian average when it comes to having a will and power of attorney documents in place. Just about everyone has answered. There we go. And you can see the answers. About 70% of you have a will in place. Great job. Definitely better than the average. Some don't yet have a POA to go along with their will. 17% say it may be out of date, and about 7% of you are looking to get this done for the first time. Okay, thanks for sharing. So now I'm going to hand it over to Sarah, Sarah Hillier. She will introduce herself, and Sarah and I will be going together through the presentation today to talk about these learning outcomes we're going to achieve. Go ahead, Sarah.
Thanks, Ellie. Appreciate the intro. Super quick, just a little bit about me. I've been dealing with estate planning and estate settlement for a very long time, and helping families with, what are their important considerations and what they need to know in order to make decisions around these important topics. And my whole goal is to always make the topics approachable. They can be highly technical in nature, but we want to offer sensitive and practical guidance. And that's always been my approach. So I hope to do that with you guys here today. In terms of starting with the basics, just to make sure we're covering what actually is an estate plan and defining that. I'm sure many of you are already well aware, considering most of you already have a will in place, but let's just cover it real quick to make sure we're all talking about the same thing. So of course, estate planning, the simplest definition is really arrangements for what happens with your assets when you pass away and who will be responsible for them. I'll also add that incapacity planning is an element of estate planning as well. And the documents that are typically involved are your will, your power of attorney for property to manage your assets if something were to happen to you, and your power of attorney for personal care to manage you as a person and your healthcare needs if you were to become incapacitated. Healthcare directives, which can go into more details about your wishes if you were to be incapacitated concerning your medical care. And in some cases, a living trust or inter vivos trust may be applicable if it's appropriate to set one up during your lifetime. Now, to take it back to not just what the definition is, but what's the actual purpose of estate planning, which I always try to keep in mind as we move clients through the process, is what you're trying to do really is accomplish your wishes. That's probably the most fundamental and important part of estate planning is actually successfully carrying out your intentions when you pass away. But some other important purposes are also, seeing what efficiencies you can develop and potentially savings, as well as customizing for your specific circumstances and what you actually want to accomplish in your plan. And finally, last but not least, it also is around establishing simplicity for your loved ones. And I think oftentimes people think that most people would like to keep things simple. I think that's generally the goal. And when you think about doing estate planning, sometimes it feels like things are getting complicated because you have to think about a lot of different things, and there's a lot of nuances to estate planning. But the reality is, if you don't think about those things, then that's what actually causes complexity for your loved ones. So, thinking about your plan carefully now is what actually helps create the simplicity, down the road for your family. There's a number of reasons why planning matters that I kind of alluded to already, but I think I've listed some of the most obvious ones here. And I won't go into a lot of detail on this, but of course, estate planning is a lot about the obvious thing is, developing savings and efficiencies. We want to avoid paying taxes where we don't need to, or other kind of fees where we don't need to. But it's also about protecting your loved ones, protecting, your assets and the wealth that you've worked hard to accumulate, and setting up your family for success in receiving their inheritance from you, free from conflict and strain, and taking into account, their individual circumstances and needs. So without further ado, I'm going to walk you through the estate planning process, kind of step by step. And as Ellie mentioned, I'll be talking about a little bit of case studies to kind of illustrate the elements of the estate planning process. So the first step is you want to, of course, compile all your pertinent information and documents. Now, without this step, you actually can't effectively consider all of your estate planning needs, right? So when you do this step and you compile all your pertinent information and documents, you do want to make sure that you're being thorough and you're not forgetting anything. And thorough as in, all of your assets, all of your, sort of pertinent things, accounts, anything that your executor will have to potentially deal with is something that you should compile when you're doing your estate planning. You do need to think practically and consider access. That's important. And by that, I mean, even physical access can sometimes, be important and a challenge. For example, many people put their original will in their safety deposit box, but if your executor doesn't know that it's there, or even that a safety deposit box, you have one, then there's going to be actual trouble for them trying to access the document. And the bank doesn't just let them, walk in and open it up, right? So these are the kinds of things that you actually need to think through. What I always caution people on the don'ts is you don't want to forget about sentimental value. So important to think about that. Personal effects is typically something that can cause a lot of stress and strain in an estate settlement because, what you may not realize about your families being, connected to certain items, if you've never had those discussions, and that's important. You can't assume that things will be dealt with. you must address it in your estate plan. And of course, you should leave no stone unturned. It's very, very common in an estate settlement. We call it the treasure hunt, where we're trying to figure out, okay, where are all the assets? How do we access them? How do we access information about them? And it's really important that when you compile a list, nothing is missed, because otherwise it actually may not be dealt with. Your executor may not realize that it actually forms part of your estate. Now, one case study that I'll share with you, and I think it's super relevant today with all of the use of technology in our lives every day. So this case study is about Priya, and Priya actually passed away after a lengthy battle with cancer, and she survived by the love of her life, Omar. They'd been together for many years. And Omar was obviously devastated by losing his partner, but he did take some comfort knowing that Priya was an avid photographer, and so she had many, many photos that she'd taken over the years stored on her computer, on her phone, and he knew that he'd be able to go through those and make photo albums and kind of have a constant memorial for her through all the photos that she'd taken of them and their family. Now, unfortunately, after Priya passed away, Omar realized at that time that he doesn't actually have all the passwords for her electronic devices or her various online accounts. And so he attempts to access these digital accounts by contacting the service providers, the actual social media platforms, anywhere where she may have uploaded photos or stored photos. But due to privacy restrictions, none of them were actually willing or able to provide him access to these accounts. And this is kind of a complex nuance where, it's not clear in all cases who should have the authority to access digital accounts, whether they're truly considered an asset, and the executor therefore has the right to access them, or not. And companies are notoriously cautious about privacy and protecting privacy, and that typically takes precedent over the very common real problem of loved ones trying to access their photos. So unfortunately, in this case, the result was that Omar was unable to retrieve any of those treasured photos, videos, contact information, or other data from his wife's devices, unless he went through the process of obtaining a court order, which can be lengthy, and in a case like this, may or may not go your way, and also expensive, of course.
Yeah, that's an interesting one, Sarah, and I'm glad we're talking about this because it says a lot to how things continuously evolve, right? Like technology has evolved significantly in recent years, so it's important to consider when you're doing an estate plan that it's much more than just a will. You need to think about all the different angles that need to be considered, and social media is a huge part of our lives. It's the way a lot of us communicate with each other, and you understand Omar taking some comfort in like, okay, well, I'm going to have access to this amazing vault of photographs, but when there's an entanglement and a trouble there, it's just heartbreaking to think about. So think about that when you're doing your estate plan. How are people going to be able to access all of your different social media accounts that have different passwords if you're updating them? Sometimes they might have the same password, but
Yeah, yeah,
yeah, make a
yeah,
plan for
exactly.
that. And there's also different platforms with different, processes that you can go through, like your Facebook, for example. I believe there's a way that you can go in and pre-plan for these things. So make sure that's part of your estate planning.
Yeah, absolutely, Ellie. I know Facebook has something called the legacy contact, where you can add a trusted person that's also on Facebook to kind of control your profile if you've passed away. But even just a lot of times these profiles of folks online, they continue to stay active after they've passed away, and even that in and of itself is sometimes upsetting for family members, because their account may be hacked, or just that they're out there and there's no you know, there's no kind of notice that the person has passed away, and that's hard for people to deal with. So it's a great example, I think, of something we can improve upon if we're doing proper estate planning. So the next step in the estate planning process is considering your goals as well as your beneficiaries. And what's really important here, I would always emphasize, is that you need to focus on what's right for you. And that's not the same from one person to the next, right? And although there's a lot of themes when we're talking about goals in estate planning, everyone is unique, and people may have the exact same, you know, set of assets, but they may have completely different concerns about their family members or their beneficiaries, right? Or they may be dealing with different family dynamics or different personalities, or different concerns in general. So I think it's important to remember that it's about you and your specific circumstances, your specific assets, the ownership structure of your assets, and that's unique. And when you think these things through, it is also important that you're thinking specifically about things. In other words, that, you know, you're not just thinking, you know, super broadly, oh, I just want to create some savings, or, you know, you have to actually hone in on what you want to do with each specific asset. You know, is it to be transferred to someone? Is it to be sold, and just the proceeds form part of your estate? And what are the logistics around those things? You do also need to have some sense of your priorities in terms of your goals, because at times there may be goals that actually compete or conflict with one another. For example, you may want to accomplish probate savings, but probate savings may create other complications where it makes your estate, you know, less simple, for example. And so in that case, you have the competing priority of accomplishing savings versus keeping things simple. Those are some examples of you know, things you need to make sure that you do. In terms of what you want to make sure you don't do, it's certainly you don't want to let others dictate matters, and it's, you know, your estate plan is exactly that. It's your estate plan, and there is no one else, whether it's a family member or a beneficiary, or anyone else for that matter, that should influence how you go about distributing your estate. That's entirely up to you. And while people can make suggestions and maybe recommendations and give you guidance, it's really you that is calling the shots when it comes to your estate plan, as it should be. You also want to make sure that you're not overlooking any specific circumstances of your loved ones. If your beneficiaries, for example, if there's concerns about, maybe they're in a relationship that you're concerned, there may be a breakdown in that relationship, maybe they, you know, one of your beneficiaries may have a disability that you want to make sure you plan carefully for. You know, there may be vulnerabilities that are involved, you know, mental health, or addiction or things like that. You want to actually think through all of your loved one's circumstances to make sure that your plan is setting them up for success. Okay. And I think this last one is a really important one. Don't assume everyone will understand. While everyone may respect your wishes, because hopefully they're your wishes, they may not necessarily understand them. And this can lead to strain and stress, and perhaps even a failure of your loved ones to actually respect your wishes, and maybe create a legacy that you didn't intend to leave to them. In this case, I'm going to talk a little bit about what I call the unwanted trust. In this case, Patricia and Joseph, they have two daughters, and they've appointed them as their executor and trustee. Now, Alex is their daughter. Alex is married, but she has expressed concerns about her relationship to her parents. Things aren't really going well at the time her parents are doing the estate planning. And as a result, Patricia and Joseph create a testamentary trust in their will in order to guard against or protect Alex's inheritance from any potential division with her spouse in the event of their their breakup, basically. So they thought to themselves, let's be proactive and let's make sure that we're taking steps to protect Alex's future inheritance if something happens with her marriage, so that her inheritance will, remain hers. And she won't need to divide it with her spouse like she would need to with her net family property, typically. Now, they don't have the same concerns for their other daughter, Kara, and so they don't create a trust for Kara. And they also don't explain what they've done in their estate plan to their daughters. Now, what ends up happening is when they pass away, which is a few years later, at this time, Alex's relationship concerns are really behind her. Everything's going really well. And they're getting along well. And she doesn't even really remember that there was a time when there was issues. When they actually see the will and understand the distribution plan, Alex is actually quite shocked. And so is Kara, that they've created a trust for Alex, and they haven't created a trust for Kara, and they don't really understand why. Now, in addition to that, in this case, they had named their daughters as executor, and they did not name a specific trustee of the trust for Alex, which means both daughters are expected to be trustee of the trust for Alex. Now, the result of that is quickly, the relationship between the two siblings becomes quite strained, because I believe in a case like this, there's a perception that the daughter who receives the outright distribution is actually favored over the daughter who receives a trust distribution because she's not capable of handling it, or, they're jumping to all sorts of conclusions, really, about why their parents did this planning. And on top of that, now there's the added pressure of them not really understanding what the spirit of this trust was that their parents created, and they have to make decisions together about distributing funds from this trust for the years to come. In fact, for Alex's entire lifetime. So this obviously creates a lot of stress and strain in their relationship. And I think there's probably a good lesson here about how you can deal with it.
Absolutely. I mean, the parents definitely had the right feelings in mind, I think, when they first went out to do this, because it's important that their legacy remains within their family. That's a valid concern. And I think a lot of people have this problem when they're doing their estate plans and considering the dynamics between beneficiaries. If there is an in-law that they aren't too sure about at the time that they're making their plan, this is something that is available as a type of solution. However, it comes with these problems potentially if you're not properly communicating why you're doing this, right? If people don't know why this has been set up, we can't blame the daughters for being a little bit taken aback, and especially Kara. What's going on here? Oh, sorry, Alex. So yeah, make sure you're communicating your intentions, and so that they understand why it's actually a safeguard. And also, perhaps this could have been revisited, right? And maybe this is something that didn't have to remain within the estate plan.
Yeah, absolutely, Ellie, absolutely. In terms of the next step in the estate planning process, it's a very important step. I'm going to say all the steps are important, but this certainly is a very important one in terms of how smooth your estate settlement will actually go. And here you really do want to choose very wisely. And your executor should be someone who is able to deal with legal matters, financial matters, administrative kind of burden of paperwork, bureaucracy, all the steps, and kind of keep a level head and be able to handle communicating with the other kind of stakeholders in the estate settlement, other beneficiaries and family members. And all of that is, there's perhaps there's some personalities that might be better suited for this type of role and some that aren't. And that needs to be thought through very carefully. And then, I think we also need to remember that even if your loved one is the type of person who's like, I actually really love forms, which is rare, but even if they were like that, they're still grieving, right? Because they've just dealt with losing you. So even if they're the type of person who you think is well suited to this, they will also be grieving. And I think when you think about the amount of hours that it actually takes, which is hundreds, literally hundreds of hours to administer an estate over a period of, anywhere from 12 to 24 months, this is a significant burden. So it's really important that you select your executor wisely, and that you trust them to make decisions with a with and be able to be impartial to all of the parties that are involved. It's very important. And this is a step that's so often not considered, but you actually need to inform them that you expect them to act as your executor. Realistically, you need to ask them, and they should have some awareness of actually what they're getting themselves into. So they should know what the typical responsibilities of an executor is. And I should mention also, a power of attorney for property, a power of attorney for personal care. If you do have trusts, you're a trustee of those trusts. And, then there's also, if you have minor children, guardians, all of these folks are, considered representatives in some way. And so you need to think through and inform them of the responsibilities and ask them, if they're willing to take that on. Super important that I always say this, that you don't just follow status quo. There was a point in time where literally everyone just appointed their eldest child as executor, and that was just like, that's just what everybody did. And it didn't matter if they were actually the best suited person to act as the executor. It was kind of automatic. And I think we've probably evolved from that to thinking a little bit more carefully and practically about who should act as our executor. And it's important that, we don't just look at it like, well, if it's good enough for what my parents did, then, it's good enough for me, because that's not, I don't think that's fair to say anymore with how much things have changed and how much more complex the states have gotten, et cetera, et cetera. Definitely don't underestimate the power of your POAs. If you choose the wrong POA, they could actually destroy your estate before it even gets to your executor. So that's really important to think about as well. And don't assume everyone will get along. Parents, I'm a parent myself, and I would love to think that my 3 kids are going to be best of friends forever and ever. The reality is, that when children lose their parents, often the parents are kind of, the glue, right? That's kind of that's keeping everyone on their best behavior, or at least on reasonable or amicable behavior. And tensions often rise after parents pass away, right? And old hurts come bubbling to the surface. And it's very, even in the best of circumstances, even with the best of relationships, estate settlement is still very stressful and strenuous on relationships, because not everybody understands the process equally. And so this creates a lot of tension and stress. So it's important to note that. In terms of the case study that I wanted to talk about here, in this case, we're going to talk about John. Now, John created a spousal trust in his will because he wanted to benefit his current wife if he were to pass away before her, and have her have access to funds during her lifetime. But he ultimately wants to make sure that the balance goes to his son from a previous marriage. Now, in his will, John really included pretty broad powers to take from the trust for the benefit of his wife, Megan. But he made Henry, his son, the executor and trustee of his will. Now, after John passes away, what he didn't realize is that Henry is really in a position of conflict, because Henry is actually the residual beneficiary of the trust. So he's going to eventually receive the balance of the trust that John created for his wife, Megan. Now, Henry is also in charge of making decisions about how the trust funds are invested and when and how they're distributed to Megan. Other than the income, if Megan needs extra funds to help her with her expenses over and above the income that the trust is earning, Henry's the one that's making the decisions about whether or not those funds get released. So in this case, Megan's got to make these detailed requests to Henry to try to rationalize when and why she needs funds. And he seldomly approves it because he's not acting impartially, and he's prioritizing preserving the balance of the trust for himself when Megan eventually passes away. And this is not really in keeping with the spirit of John's intentions.
Yeah, you can see that John did have the right intentions, right? Setting up a spousal trust, making sure that Megan's going to be comfortable, having an enjoyable lifetime with the level of comfort that she's accustomed to, right? That was the idea. And that it does make sense that the residual beneficiary is his son. That's where he wants it to go, as opposed to being passed along through Megan's family, for example. So great intentions. However, yeah, you have to be very careful about this because John trusts Henry, obviously, but Henry is in a difficult position, and whether he's consciously doing it or not, perhaps, right? These things can happen where he just knows that whatever's left is coming to me, and who knows what his circumstances are as life progresses for Henry. So keep that in mind. It might be best to have a neutral third party to be the trustee if you're going to set up a spousal trust. That would alleviate a lot of stress and keep relationships together.
Yeah, absolutely, Ellie. Now the next step is kind of a big one because this is the stage where you're basically considering what potential strategies and efficiencies, protection, savings, all those kind of customized things for your situation that you want to think through. And in this case, I would say, highlight typically the first thing people are thinking about is, of course, probate savings. In most provinces, there's some type of fee, and often that fee is significant. For example, in Ontario, it's 1.5% of the value of the estate over $50,000. That essentially gets paid to the government and on the value of your estate assets. And then, but that's not the only consideration. I think my case study here will illustrate that very well. But so you do need to be careful with beneficiary designations, because when you make beneficiary designations where you're naming a specific individual, or organization, you're on a registered account or a life insurance policy, you're taking that asset out of your estate and it won't be dealt with under your will. So it's important that you think through the strategies and efficiencies that you're trying to develop and map out what the impact will be. One important thing to do is consider trust planning for sure, just to get a sense of whether or not there's benefit for you. Certainly, if you have minor children, a trust would be needed, but there are some other circumstances where you might want one for protection or efficiency. Now, it's important that you also don't think only about the money, although we would like to make sure that we create as much savings as possible and reduce expenses as much as possible. That's, of course, not the only consideration in terms of strategies. And it's not the only type of efficiency that we talk about when we're doing estate planning. We're also talking about practical and logistical efficiencies as well. And of course, you don't want to forget about your liabilities. Now, in this case study, I'm going to talk a little bit about paying the tax bill. Okay. In this case, Chris had named his son Noah as executor, and Chris has 2 kids, and he's named them both as the beneficiaries under his will. Now, just like I just mentioned, Chris is concerned with avoiding probate, so he's actually named his children, Noah and Sophia, as beneficiaries directly on his RIF account, his Registered Retirement Income Fund. And at the time of his passing, his estate consists of a bank account, his non-registered investments, and his RIF, which is the most significant portion of his estate, $225,000, and his vehicle. Now, because he's named his children as direct beneficiaries of his RIF, it goes directly to them outside of his estate. But meanwhile, the RIF being distributed due to his death actually triggers income tax. And that is where there's no spousal rollover available. The entire value of the account is treated as taxable income in your year of death. So that can generate a very significant tax bill, right? And in this case, the entire accounts already went out directly to Noah and Sophia. Meanwhile, Noah has to deal with the estate, file the tax return, figure out what that tax liability is, and is expected to pay it from the estate assets. In this case, the estate assets are not sufficient. And by the time Noah realizes this, Sophia's already spent most of the share that she received directly from the RIF, and she quickly becomes uncooperative with him because she doesn't really understand, well, why do I have to pay that? That's not, but the reality is what ends up happening is CRA knows who received the proceeds of the RIF account, and they will and have far-reaching abilities to actually pursue collections from folks that they know received a portion of someone's assets when they have it, in the tax bill is dealt with separately and technically should come from the estate assets. So CRA will continue to pursue both Noah and Sophia until the entire tax liability is paid. And that's regardless of whether or not Noah is willing to pay his share. So even if he's willing to pay his share, they're still going to keep pursuing him until they get all of it, unfortunately.
Yeah, so a few things to consider here. Noah was so focused on avoiding that probate tax that he went ahead and named his kids, and people tend to get really hung up on probate. And I don't want to pay that 1.5%, but great. I mean, there's lots of ways that you can do that. The spousal allowance there for the RIF would have been fine, but it's different when it's kids. So keep that in mind. And there's also the possibility that, Noah didn't know how much it was going to be until after he'd received the authority to act on the estate and started doing the work. It could be months down the line after Sophia has already received her inheritance. So she's also in a tough spot. So this is really difficult. And what it means is you need to take that next step. The holistic planning is where this comes in, where let's think about all of the consequences of this decision, right? Let's make sure that we've got everything in place so that the inheritance is actually not a burden or causing pain to your inheritors. That is further from Noah's initial intention. So yeah, take that extra step.
Yeah, wonderful, Ellie. So now definitely what you need to do is understand how everything fits together. And you need to always think a lot about right now and a little bit about the future, rather than what I see people sometimes do, which is the reverse, because we're all thinking that our death is very far away. But we do need to think about what are the circumstances right now. If I were to pass away tomorrow, unfortunately, what would happen, right? And map everything out together. This would have also helped, in the previous case study, is actually mapping out, okay, what are the buckets? Where's everything going? Where are the expenses and liabilities coming from? And so the don'ts here again are like, don't plan anything in isolation, right? Everything has to fit together. And that's a very, very important. And this is an often overlooked step, by the way. The story that we just told is actually a very common occurrence in terms of, from what I've seen, where the no one actually really mapped out where the funds would, come from. So, and it created significant problems in the estate settlement. One thing I always say is really important is don't fail to align moral and legal obligations. And the next case study is a really good, perspective on that. We get asked all the time if people should joint their assets or joint their accounts with their adult children in order to avoid probate. And that's exactly what Dina has done in this case here. She has 3 adult children, and she's appointed all 3 children as her executors, and her will is going to distribute her estate equally between them. Now, as she gets older, she doesn't become incapacitated, but she does need some help. And so she adds her son, John, who lives the closest to her, as a joint owner on her bank account so that he can go in and deal with her day-to-day transactions and pay her expenses, etc. She still expects this account to form part of her estate. Now, when Dina passes away, they begin the estate settlement. And when John goes to the bank to give them, a death certificate and kind of start the process, the teller simply informs him, oh, that's a joint account. So you're the surviving owner and it's yours now. And so John says, oh, okay, that sounds great. He transfers the balance to his own account and those funds are now his. Now, when his siblings find this out, they're furious and they know that this absolutely wasn't their mother's intention. In this case, unfortunately, what ends up happening is Jeff and Jennifer take the matter to court. Because they're taking the estate to court, they can't also act as the executor. So now they have to remove themselves as executor, which was also not their intention or their mom's intention. And eventually, and their other sibling can't act as executor. So now they need a neutral executor. They have to hire somebody to do that, of course. Now, eventually, the court does rule in favor of the siblings, Jeff and Jennifer, because actually the presumption under the law is that a joint account between a parent and their adult child is intended as joint for convenience and not actually true joint with right of survivorship. So actually, the bank acted incorrectly by allowing John to just take the funds from the account. But this actually is a common error that can be made easily. And of course, it creates a significant issue in the estate settlement because now people have to go to court and it becomes very tricky to deal with. And relationships are often can't be salvaged after something like this.
Yeah, we're seeing this more and more often, right? In these case studies, it's about relationships as well and making sure that everything stays intact. But gosh, this really ran off the tracks, didn't it, in terms of Dina's original intention, just because of one person's actions. So, of course, it's important to be really specific about what you want to have happen. Make sure that's recorded. And if there's a way to do it explicitly with the bank, then make sure they know and they understand what your intentions are for that joint account. So document your intentions, and then make sure the bank acknowledges what your intentions are.
Thanks, Ellie. Yeah. So this is kind of, we're nearing the end of the process here. It's really important that you communicate your plan to your loved ones and that you actually revisit that plan, right? As circumstances change. We do encourage family meetings. I know that's not always possible and it's not people's most favorite thing to do, but it is something that I recommend and it's important. And that you again inform your executor, anybody you expect to have a role, you make sure that you talk to them about it, and that you certainly revisit any time something changes, a birth, a death, etc. And don't overlook jurisdiction. That happens a lot is when somebody moves even from one province to another. There are nuances in legislation, and so it's important you revisit your estate plan, and don't think of talking about this stuff as taboo, right? It's important that we become more comfortable as a society talking about these things because it's only going to help lead to better relationships between family members and more chance for success in terms of having things go smoothly when the time comes. One last case study I'm going to talk about here is, in this case, I call it the favored grandchild, unintentionally favored, I think. But in this case, Elijah has 2 kids and 3 grandchildren. And the last time he updated his will was after his first grandchild was born. He was very excited that he had a grandchild. And the first thing he did was went and updated his will and added a special gift for his grandchild to his will. He wanted them to have an amount if he were to pass away, and he wanted them to have it right away. So wonderful gesture, amazing that he did that. Now, after he had more grandchildren, he didn't ever revisit his will. And when he passed away, only his first grandchild, Nathan, is actually going to receive a gift from his estate, because when he did that will, Nathan was mentioned by name. So it wasn't a class of beneficiaries. It wasn't, the wording was not, I want my grandchildren to receive a gift. It was, I want my grandchild, Nathan, to receive this specific gift. He didn't remember that that's how he had done it, and he had just assumed that all of his grandchildren would receive the specific gift. Unfortunately, that wasn't the case. And so this is where things can really go awry, because now in an otherwise harmonious, family and relationships, there's now tension because it is as if this grandchild is favored, which also means naturally their parent is favored. So now there's issues between the siblings, between the cousins. And even though one child wants to correct the imbalance, that would take the other child agreeing to that, because they would basically be volunteering, a portion of their share of the estate to provide gifts for the other grandchildren. And obviously, that doesn't always work, right?
Yeah, so Elijah, great. He was on track. He had a grandchild he knew that was a major life event, and he went and he updated his will. Fantastic. However, it was a little too specific, perhaps. And so you do have to keep paying attention to that. When something big happens in your life, try to have that little bell in your mind that goes off saying, oh, I need to look at my estate plan and make sure things are going right and that it's going to accomplish what I want, right? And then again, we have the relationship strain here because yeah, I mean, simple solution. Let's just equalize it. But that means people have to agree, and this is a sticky situation that could have been avoided with regular revisiting of the estate plan.
Yeah, and that example goes back to, again, moral and legal obligations. You want them to align, right? They may have a moral obligation because they know that that was your intention, but it's not a legal obligation.
And I'm sure nobody has a favorite grandchild.
No, of
No.
course. Unless it's me, I'm the favorite. So in terms of one last kind of thing for your consideration in terms of the estate planning process is you should really consider seeking professional guidance when you're doing it. I know there's a lot of probably conflicting information out there about how you can do it, can you DIY, et cetera, et cetera. I do encourage everyone to, consider getting professional guidance and to do it early on in the process, and to really think about if you can take advantage of the type of professionals who don't just dabble in estate planning, but actually deal with it all the time. In a lot of cases, there might be lawyers who can prepare a will, but they've only done it a handful of times, right? So it's important that you think about, okay, how much of their practice actually is around estate planning so that you can work with the right kind of experts or specialists. And don't take advice from just anyone. I hear all the time people saying, oh, my neighbor or my coworker, they said to do this. Please, that might have worked perfectly well for their circumstances, but or maybe not. You don't really necessarily know. So don't take just advice from just anyone. And last but not least, don't get overwhelmed and give up, because I think that does happen because the estate planning process causes you to, it's homework and, it's a lot of heavy things to think about. It's not necessarily fun, but it is so, so important that you just keep going and that you move through the process, with the end in sight, right? I'm going to skip this one actually. So in terms of takeaways for what we want you to get out of today and make sure that you understand is that you absolutely need to have an effective estate plan, emphasis on the word effective. You want to get help from appropriately experienced professionals. You want to always consider your goals and create a plan that meets your needs. And you most certainly want to communicate and revisit your plan as your circumstances change.
Okay, so we have another poll question here. So given what we've covered, do you think it may be worth reviewing your estate plan? So yes, I think I should review my will and estate plan. No, I'm confident that my affairs are in order and my wishes will be met as intended. Answers coming in.
I'm not allowed to answer, but I was going to say, even I'm not 100% certain.
Okay, well, congratulations to 82% of you that think you should review your will and estate plan. I'm glad that we were able to get you thinking about that today. And I suppose also congratulations to the 18% of you that
Yes.
don't think you need to review your
Sure.
estate plan. But this had the intended effect here on this crowd. It's important to have a look and consider everything, the way people interact, and also take account of how people may behave after the fact. You've got to be talking about what's in your estate plan as much as you're comfortable with, and make sure your family's informed and that it's a current reflection of your current state, right? And your estate plan needs to be something that would work if you needed it tomorrow. And we don't want to think about it, but it's true. So here at ClearEstate, we're available to help you with this. We've got all of the experts here on staff. Sarah is in charge of our wonderful team of people on the estate planning side. And we've got everything from our network of attorneys, tax specialists, empathetic and caring estate plan advisors and customer success managers and other people here at ClearEstate. There's more than 80 of us on staff. And we're all focused on making sure that everybody has a good estate plan that is reflective of their unique needs. And keep in mind as well, we're here to help with estate settlement. So when it comes to our professional fiduciary services, keep us in mind as well. We can be that partner in your estate plan, along with our fiduciary partner to act as the agent to professionally manage your estate settlement. So you can go through all of the estate planning with us, but then also know that we are set up for success to be able to settle your estate effectively and therefore alleviating the liability and burden from your family. We're going to be quick and efficient when it comes to settling your estate. We'll keep your loved ones informed and we'll do an excellent job of it. The people that were involved in creating your estate plan are going to be involved in the settlement as well. So you've got a continuity of professionals. We are, again, 1/3 of the cost of lawyers in most cases. We're very much affordable, a really good option. Our fees, as you will see if you book a consultation with us, are really something that can be handled. We're independent, we're impartial. So a lot of these case studies we went through, it would have helped a lot to have somebody who is impartial to the situation and just wanted to carry out your wishes as you set them out, right? We're going to address complex needs and strategies and just help you leave the legacy you intend. And okay, yeah, here's a special treat for attending the webinar today. So it's important for you to know this. We will give CARP members 15% off of any estate planning and professional executor services that you book with us in the month of April. So this is limited time. So dust the cobwebs off in the spring on your estate plan and get something updated with us here at ClearEstate, 15% off, and you get $25 gift card just for attending your consultation. We have so many questions that have come in, by the way, that I encourage you please to book consultations because we'll be able to get more specific about the questions that you're asking. And then for our simple online will, which is a very straightforward product that we've released this year, the code WILL25 will get you 25% off. And you can share that with your friends and family. So if you have younger folks in your lives who need that will for the first time, and they have a very simple plan that they need to put in place, feel free to share that code with them, WILL25. All right, so we have hardly any time for Q&As actually, but I'm just going to try to pick out some themes. I'll go over here because some people submitted them beforehand, and then we have a lot that have come in during the presentation. Let's say, let's go back to a pretty popular question here, which is about adult children who don't have wills yet. Should they make a list of their accounts for us too? What happens to all of their assets if something should happen to them? So this person's asking about their kids, which is really sweet. Make a will. So we've just provided you a pretty awesome solution, 25% off our online will, which is how much? It's less than $300, correct?
Yeah. Yeah.
Yeah. So, that's a great starting point. Of course, having those conversations and understanding what each other's assets are and what your plans are for them is also going to go a long way. Here's a specific question. Okay, Sarah, I'm a Canadian living in Canada, but I want to leave some money to someone in the US. How can I do this with the least complications for my estate and my executor?
Yeah, that's a great question. And the answer, and I'm going to try to be as brief as possible. There's considerations that the beneficiary in the US will have to kind of deal with and address on their own with the tax professional that's kind of familiar with cross-border issues and things like that. But generally speaking, I don't consider it very like punitive in terms of like what ends up happening with taxation. There are treaties between countries and there is withholding tax that gets applied to foreign beneficiaries, but it's only around income that's earned in the estate after you pass away. And so that may be very little, it may not be, like, just depends on what your assets are and your circumstances. But that, the idea is, the government always wants to make sure that they guard against a foreign beneficiary, not paying tax on income. And that's why there's withholding tax. There's not a lot you can do to address it if, your estate is here. But that's, understanding it is probably a good step, and making sure your beneficiary knows to seek out tax advice in their jurisdiction.
Okay. I'm seeing a lot of questions that have come in that are quite specific to people's lives. So I hope that we'll be able to be of help to you. I encourage you all to book an appointment with us to have that free consultation to get some of your specific questions answered. But on a general theme, I do see a few questions related to choosing an executor. So we've got like one question saying, my executor, do they have to live in Canada or even the same province? And other questions about, how do I choose one? And what if I don't have a spouse or children to appoint as an executor? Quite a
Yeah.
few. Yeah.
Yeah, great. I know, great question. So there's definitely, there's considering a professional executor is certainly a really good option. I think obviously, ClearEstate, the way that we're doing things is quite different than the traditional options that are typically available, which is, going to a lawyer who's potentially, paying, charging the full amount that they're entitled to, which in most jurisdictions is 5% of the value of the estate, or a trust company who has some type of, blended fee schedule based on the value of your assets, where ClearEstate is a much more affordable option and a much more practical option. But I would say if your executor is not in your jurisdiction, it's going to make it challenging for a number of reasons, practically, logistically, but also there can be tax implications, and the court may require a bond, which creates a whole nother expense, and timeline and complication to your estate settlement as well. So definitely, I think considering a professional in any case is something worthwhile.
Yeah, there are definitely options out there. Sarah, can we back the slide back to where people can call us and see
Yeah.
our website link? People are just asking. So there you can see, book a free consultation, clearestate.com/CARP, or just call us. There's the number 1-866-994-3695. Thank you so much, everyone. We are now at the hour, and I appreciate all of the questions that have come in, but I encourage you all to get in touch with us. We are here. We're a big team of people that are happy to speak with you about your estate plan questions. And thank you so much for your time this afternoon. We'll just leave this up a few more seconds. Please take down the info. And remember, this 15% off is just for the month of April. So if you want to get paying attention to your estate plan, let's get going. There's no time like the present.
Thanks, Ellie. Thanks, everyone.